Number one, beneficiary designations. Beneficiary designations are probably the most important thing that financial planners do correctly for their clients. Number one, the most common mistake that I see by financial advisors when they are creating the beneficiary designations for their clients is they will put one child as the beneficiary for the purpose to distribute all the property to the other children. This is a horrible decision. Do not do that. Always list out all the children, because you got to remember, when someone passes away, the beneficiary designation tells the financial institution where to distribute the money. The second most common mistake made when putting a beneficiary designation is putting one person as the beneficiary for the purpose of taking care of a child. This is a horrible decision. Giving money to someone's brother or sister or a close family relative for the purpose of distributing that money to a child throughout their life is not going to work. What the people really need to do is they need to see an estate planning attorney to create a trust for the benefit of that child. The second biggest mistake that I see from financial advisors when they are trying to help their clients in their estate plan is they put family members as joint owners on accounts. Usually the scenario works like this. Mom walks in, her husband has passed away, she's by herself, and a young son who is very trusted and very loved by the family is put on the accounts so he can pay her bills and handle her financial affairs. This is a really bad idea. And the reason why is when you put someone as a joint owner on an account, that means they own that property. And let's say for some reason that in this account there's $100,000. Well, son, he owns a business, he's running it just fine, and little does he know, he didn't pay his employment tax correctly for the last 2 years. IRS comes after him, they place a lien, and then they find this account of $100,000 that he is just supposed to be paying mom's bills out of. IRS doesn't care that this was mom's money. They will take that money to satisfy their debt. This could be a huge problem. And guess who they're going to come look at when that money is gone? Their financial advisor. So do not put family members as joint owners on accounts. What they really need is a trust in order to handle the finances, and the son is the trustee, or two, some kind of power of attorney. A third option that could be used would be setting up a separate account that had a small amount of money in it this to pay the bills every month, and money from a larger account is distributed to it. But those are the ideas. Number two, do not put family members as joint owners on an account. Number three, abuse by children. You've probably been in that awkward situation where you've noticed that a child has come into their elderly parent's life and is controlling them. If you've been a financial advisor for a long time, you've seen it. You love your client and you want to help them, but you also know your client trusts their son or daughter or whoever it is to take care of their financial affairs. The only way you're going to truly help this individual is by getting other people involved. Contact other family members. Have group meetings. The more people that are involved, the more that they will start to see what's really going on. Now, the abuse I'm really talking about here is financial abuse that's happening. It's very common for when an elderly person is about to pass away, they start losing mental faculties and they start agreeing to things that they would have never agreed to earlier in their life. The other last effort that I would give is if family members cannot control or rein in this problem, get an attorney involved, maybe an estate planning attorney or some other attorney to come in and sit in on discussions. This can help out. I've often tried to get my family members or these people to contact the elderly abuse hotline for the state of Texas. What I have found out is the elderly abuse hotline will most likely say, Mom can make her own bad financial decisions. So it's not going to be a good method of handling the problem. Just remember the two things: get family members involved, or two, get an attorney involved. Number three, if it's really bad, go to the state of Texas and they can help your mother or help your elderly client in their situation. Number 4 and 5 are going to kind of go together. Number 4 is don't review your client's estate planning documents. Review connotes the idea that somehow you have the legal expertise to understand that the estate planning documents were drafted correctly. You don't want to review your estate planning documents for your clients. You just want a copy of them. If you have a copy, you can put these copies on file, and then on your side, maybe you can read through them and bring up any concerns that you may have with your client as you read through them. But never tell your client you're going to review. That signifies that you're making some kind of legal decision for your client. And you don't want to be sued because you reviewed the estate planning documents and you thought that they were correct. Number 5, respect the privacy of your clients if they've drafted a trust. In the drafting of a trust, some of my clients have said, I really don't want to tell anybody that I'm excluding a son or a daughter. And this includes our financial advisor. They just don't want anybody to know this information. As an attorney, I draft a document specifically for financial institution. It is called the Certificate of Trust. That is the document that you're really going to need to know how to set up the beneficiary designations correctly. But going forward, if your client says, I don't want to give you my trust, accept the fact that they want that to remain private. These are the 5 reasons, or the 5 things that I think every financial planner should know when they are dealing with the estate planning of their client.